Good afternoon. I haven't had the opportunity to meet Mr. Spellman before, and had I known he was going to talk about numbers, I'd have made up a slide. And the first slide would be 37,000. And that is the number of children who have been poisoned by lead-based paint in their homes in Rhode Island since the early 1990s. Second number that I would have put up there, I think, is the most important, and it's the number 6. 6 is the number of jurors in Rhode Island who unanimously rejected every single argument that you just heard. Every number crunching, number changing representation that was made to you was put before a jury of 6 Rhode Islanders over 4.5 months. They came back and they unanimously rejected it. And they rejected it because they found that the fact that there is lead-based paint in children's homes in Rhode Island constitutes a public nuisance. When I was asked to come here today, I was asked to talk about public nuisance. And that's what I'm going to do. I'm not going to talk about contingency fee issues and the American jurisprudence system and whether it makes sense and whether it doesn't make sense. I think that's a debate for another day. And I think what's the important thing here is what is public nuisance and why does public nuisance fit in these lead cases? Public nuisance is one of the oldest legal claims that exist in this country. And in fact, some have dated it back to the time of the Magna Carta. It's certainly been dated back to England in the 1500s and 1600s. And here in the United States, it's been here since the late 1600s and early 1700s. And traditionally, public nuisance has been used for a wide variety of claims. It's been used for everything from an obstruction in the public road, disturbances in places, and things like that. And in the last 25 to 30 years, public nuisance has been used increasingly in environmental cases. Think things like the Exxon Valdez, Love Canal in New York, where you have this massive environmental pollution that needs to be cleaned up before it harms people. What you see up here is the definition of public nuisance under the restatement, and it's an unreasonable interference with the health, safety, or welfare of the general public. Now, that's kind of a broad definition, and it sounds amorphous. But as you get into public nuisance law, what becomes clear is that public nuisance is not a massive doctrine that could encompass and engulf an entire body of product liability, but it's actually a very, very narrowly tailored doctrine that only works in very discrete kind of cases. And in the last 8 years, it's been used in the environmental context of the lead poisoning cases. Now, to understand why it fits, you need to understand what lead poisoning is. Lead poisoning has been called the most common environmental health risk to children in the United States today. And you heard reference to Mattel and to China, and that's where the problem is, but any well-respected public health authority tells you it's not Thomas the Tank Engine from China that is poisoning children in the United States. It is lead-based paint that is in their own homes that is the most common and overwhelming source of lead poisoning. That's not a litigation position. That's a position that's been taken by the United States government, by the Environmental Protection Agency, by the Centers for Disease Control, by the American Academy of Pediatrics. Everywhere you look, everybody will tell you that that is where the problem is for children today. It's not from Mattel. It's not from China. Children under 6 become lead poisoned when lead-based paint in their home can chip or flake or deteriorate, and they ingest it. And it goes into their system, and it actually gets into their brain, and it interferes with the way their brain develops, with the way their brain grows, with how their central nervous system functions. And at very high levels, it can cause seizures, it can cause coma, and it can cause death for children. Now, since the early 1990s, lead poisoning has received a lot of attention from the public health community. And it's really unique as a medical and scientific issue because it's a consensus. Outside of litigation, there's a consensus in the medical community that lead poisoning is very bad for children and must be prevented. Since the 1990s, what the public health authorities have attempted to do is go from what's called secondary prevention, where you treat children who have been lead poisoned, to primary prevention, where you prevent children from getting lead poisoned in the first place. And the reason for that is once a child is lead poisoned, the effects are permanent and will continue throughout their life. So the best idea is to prevent that poisoning in the first place. And in 1999, it was the Rhode Island Attorney General, who is now United States Senator Sheldon Whitehouse, who recognized the problem of lead poisoning in Rhode Island and the necessity for shifting for this secondary prevention where we treat children to primary prevention where we prevent poisonings. And the primary suit, or the primary claim, was a public nuisance claim. And since that case has been filed, and other cases have been filed in Milwaukee, where the Court of Appeals of Wisconsin upheld public nuisance in lead poisoning cases, in California cities and counties where the California Intermediate Court also upheld public nuisance cases. What has come out of it is this distinction between a product liability claim and a public nuisance claim. And you see this defense that, hey, we're product manufacturers. You can only sue us in product liability. We don't belong in public nuisance cases. There's some very critical differences between public nuisance cases and critical differences that really make a difference to how these cases are tried and why public nuisance is so limited. The first is, under a public nuisance case, it's a government entity that brings a claim. It's your representatives, it's the state, it's your cities, it's your counties. It's not brought by a particularly injured individual like the product liability claim is. Second key distinction is between the remedies that are available. Under public nuisance is this amazing doctrine where the state can come to court and seek to render harmless a dangerous condition. You don't have to wait until 50,000 more children or 5,000 or even 500 more children are poisoned. What you have to do is you have to come and you have to show there's been harm or a threat of harm, and you can get a public health remedy affected. It's not money. It's not $2.4 billion check that's going to the state coffers. It's actually getting these defendants to put abatement workers in there who are going to minimize the risk of harm to children. Very different than a product liability case where the remedy is limited to damages. You have to have suffered an injury, and then a jury has to monetize that. And the third I've mentioned under public nuisance, which is it allows you to prevent future harm. You don't have to wait until kids get poisoned, which is completely counterintuitive when you think about it. Why should we send our children out there to get poisoned to fix the problem when we could fix the problem before they get poisoned? Product liability doesn't allow for that. You have to be poisoned first for anything to happen. The elements of the two claims are very different. Under public nuisance, you have to prove that there's a condition that harms or threatens to harm the public. That's a very difficult standard to meet. It's not enough that a single child was poisoned or 5 children were poisoned. You have to prove a much greater threat or actual harm to the public. And then you have to prove that the defendants in a public nuisance suit engaged in conduct that created, maintained, or contributed to that public nuisance, that they did something to result in the particular public nuisance. You can see from this it's very, very different from the traditional product liability elements. It's against this legal backdrop that the Rhode Island case was tried, and it started on November 1st of 2005, and there was a jury verdict on February 22nd of 2006. It was the longest civil trial in Rhode Island history. And there were 3 questions for the jury on their jury questionnaire. And first was whether the presence of lead pigment throughout the state was a public nuisance. Second, if a public nuisance did exist, were the defendants liable for that nuisance? And even if these defendants were liable, is abatement the appropriate remedy? Do we want to go in there and do we want to abate this before more children are poisoned.